My name is Erwin Chemerinsky, and I have the great pleasure of being the Dean of the University of California, Berkeley School of Law. In 1968, the Kerner Commission, the National Advisory Commission on Civil Disorders, wrote, "We're moving towards two societies, one black and one white, separate and unequal." It spoke powerfully of the racism policing and the police violence that was seen throughout the United States. 52 years later, as we're together now, the names Michael Brown, Eric Garner, Walter Scott, Laquan McDonald, Freddie Gray, Breonna Taylor, George Floyd, all unarmed African Americans killed by the police, are familiar to us. And of course, so many other names that we don't know who suffered the same fate. The statistics with regard to police violence are shocking. When you talk about African American men between the ages of 15 and 35, they are 9 times more likely than other men in society to be killed by police violence. For Latino men of the same age, they're twice as likely to be killed by police violence. When there's interactions with the police, Blacks are 4 times more likely to be met with the use of force than all others in society. Of course, the racism in the criminal justice system is not just about policing. African Americans are 1/3 of those in prison in the United States, even though Blacks are only 11% of the population. The recent tragic deaths of Breonna Taylor, George Floyd at the hands of the police has again focused our country's attention on race and policing. We as a law school have a special obligation to confront this issue and issues of race more generally. And so this is the first of several programs and forums that will be held over the course of the summer and the fall to deal with these issues. We could not have 3 talented, more knowledgeable speakers to address this than the individuals that I'll be introducing you to shortly. Just a word about format. It's a bit different than what we've done for our other Monday sessions. For the sake of security, we've disabled the chat. You can ask questions, and we're going to leave time for questions. And Whitney Mello will, at the end of our presentations, then read the questions aloud for the panelists to answer. There'll be 4 presentations to listen to before we get to the questions. I'll introduce each of the speakers individually. I'll apologize to them at the outset that my introductions are going to be very brief. I want to leave maximum time for you, the audience, to be able to listen to the speakers. We're going to start with my colleague, Professor Khiara Bridges. She's professor of law here at the University of California, Berkeley School of Law. She received her undergraduate degree from Spelman College and both a JD and a PhD from Columbia University. So many years on the faculty at Boston University, we were tremendously fortunate to recruit her to join us here at Berkeley in the summer of 2019. And with that, I'll turn it over to you, Khiara.
Yeah, thank you so much for that introduction, Erwin. And thank you so much actually also for proposing today's panel and for organizing it and for inviting me to speak. I will focus my remarks today on what critical race theory as an analytical framework, what critical race theory can bring to understanding police violence. And I will spend my time today exploring how critical race theory, or CRT for short, might encourage us to think about George Floyd's death just 2 weeks ago today. So there's no time, of course, for me to give a complete history of critical race theory. I will just say that CRT emerged in the legal academy in the 1970s and 1980s in response to what critical scholars considered to be limitations in traditional civil rights discourse. And one of the many ways that critical race theorists thought that traditional civil rights discourse was limited was with regard to its definition of racism. So traditional civil rights discourse tends to define racism as, and let me just share my screen here, as discrete, easily identifiable, invariably intentional, always irrational acts perpetrated by bad actors. Essentially, traditional civil rights discourse defines racism as individually held bias or prejudice. And CRT proposes that this definition of racism is woefully inadequate. While defining racism as discrete, easily identifiable, invariably intentional, always irrational acts that are perpetrated by bad actors, while that might have described a type of racism that may have been ubiquitous in the pre-civil rights era, and while this definition of racism may describe a type of racism that may tenaciously persist today, CRT argues that this definition does not describe the mechanisms that do most of the work of maintaining white people as the dominant racial group in the country at present. CRT contends that far from being discrete or cut off, racism and racial dominance are oftentimes the result of interactions of many institutions across multiple domains. CRT claims that far from being easily identifiable, racism and the recognition of an act or omission as a species of racism, that frequently requires a theoretical framework to help us figure out which societal choices inflict racial subordination and consequently ought to be designated as racism. CRT proposes that racism is not invariably intentional. In the post-civil rights era, racism is oftentimes the unintended, if foreseeable, consequences of discrete choices that we have made. CRT also denies that racism is unvaryingly intentional. It posits that more often than not, CRT also denies that racism is unvaryingly irrational. It posits that more often than not, racism makes all the sense in the world. And finally, CRT argues that while racism may be perpetrated by bad actors, it more frequently is the result of institutional structural processes in the post-civil rights era. And CRT offers that defining racism in the way that traditional liberal civil rights discourse proposes is problematic and it's dangerous. When racism is only understood as bias and prejudice practiced by bad actors, it puts outside of the field of vision all of the institutions, structures, and systems that function to maintain the nation's current racial hierarchy. With that background, consider the questions that the traditional liberal definition of racism leads us to ask when we learn that George Floyd was killed after police officer Derek Chauvin kneeled on his neck for close to 9 minutes. That definition directs our focus to the police officer who killed him, Derek Chauvin, and it guides us to an interrogation of Chauvin and his views on race. So we ask whether Chauvin has ever used the N-word. We ask whether Chauvin has any Black friends. We ask whether Chauvin listens to hip hop. Essentially, the liberal definition of racism leads us to ask whether Chauvin is a bigot. And if we determine that Chauvin is in fact a bigot, then we can be comfortable concluding that Floyd's death is a manifestation of racism. If we determine that Chauvin is not in fact a bigot, then Floyd's death cannot be understood as a manifestation of racism. Notably, there is evidence that Chauvin may not be a bigot. He was married to an Asian woman after all. Can a white person be a bigot if he is married to an Asian woman? Can one dislike Black people while loving at least one Asian person? Can dislike of Black people and love of an Asian person be simultaneous? Please note that these are profoundly uninteresting questions to ask. Now, when racism is defined in the way that CRT proposes, we are encouraged to ask different questions about Floyd's death. When we learn that the police encounter that ended in Floyd's death began because Floyd might have been attempting to use a counterfeit $20 bill at a convenience store, we might remind ourselves of the definition of a white-collar crime. White-collar crimes are generally understood as nonviolent acts that result in financial harm and that are committed for financial gain. So the crime that Floyd was allegedly attempting to commit was a white-collar crime. Note as well that Eric Garner was allegedly committing a white-collar crime minutes before his death. As a reminder, in 2014, Eric Garner was killed after police officer Daniel Pantaleo put him in an illegal chokehold. Now, Pantaleo initiated the encounter that ended in Garner's death because Garner was illegally selling individual cigarettes from a pack. Now, New York State, like many other states, taxes the sale of cigarettes and tobacco products. And New York State collects taxes from the sale of tobacco products by requiring persons who sell these products to register with the New York State Tax Commission and to prepay taxes on the sale of the products through purchasing tax stamps. Now, when Garner sold the cigarettes without a license from the New York State Tax Commission and without the requisite tax stamps, New York State was not able to collect taxes on his sale of cigarettes. So essentially, Pantaleo attempted to arrest Garner because Garner was allegedly engaging in tax evasion, a white-collar crime. So again, both George Floyd and Eric Garner were allegedly engaging in white-collar crimes before their deaths. And again, white-collar crimes are generally understood as nonviolent acts that result in financial harm and that are committed for financial gain. CRT might encourage us to ask questions about how race informs our definitions of crime. I've been thinking a lot about recessions of late. In 2007, this country was thrown into the greatest economic downturn that the nation had experienced since the Great Depression of 1929. A brief history of the Great Recession: banks had relaxed their lending practices, giving bigger mortgages to borrowers who could not provide proof of their ability to make payments on these loans. Financial institutions packaged these mortgages into securities, and when homeowners eventually defaulted on their loans, the value of these mortgage-backed securities plummeted. Banks who owned these securities were unable to raise capital, and they teetered on the verge of collapse until the government bailed them out. The Great Recession was made possible by predatory lending and greed. What I want to highlight here is that the financial practices that led to the Great Recession were nonviolent, they resulted in financial harm, and they certainly were engaged in order to reap financial gain, but they were not crimes. CRT might invite us to ask, how does race and class influence which nonviolent harmful practices that are committed for financial gain are criminalized? And how does race and class influence which nonviolent harmful practices that are committed for financial gain governments decide not to criminalize, or rather to simply leave to agencies to regulate or not? Further, if Floyd was in fact trying to pay for something with a counterfeit $20 bill, why did he do that? Why had Garner felt compelled to sell single cigarettes from a pack on the sidewalks of Staten Island, New York? What does it reveal about the economic opportunities available or not available to Floyd that he thought that attempting to pay for some goods with a counterfeit bill was worth the risk? What does it reveal about the economic opportunities available or not available to Garner that an able-bodied adult man of sound mind considered selling individual cigarettes from a pack something that was worth his time and energy? Also, what empowered Chauvin, or any police officer for that matter, to engage with Floyd, an individual who was suspected in engaging in a nonviolent crime? What empowered Pantaleo, or any police officer for that matter, to engage with Garner, who was also suspected to be engaging in a nonviolent, victimless crime? Specifically, why has our Constitution been interpreted to give the police the latitude to initiate contact with individuals suspected of engaging in nonviolent crimes? Moreover, when we learned that 46-year-old George Floyd suffered from coronary artery disease and hypertensive heart disease, health conditions that might have made the knee that Chauvin placed on his neck for close to 9 minutes much more likely to be deadly, we can ask questions about why Floyd has come to inhabit such a state of unhealth. Similarly, when we learned that 43-year-old Eric Garner suffered from a host of health issues, including asthma, that made the illegal chokehold in which Pantaleo put him much more likely to be deadly, we can ask questions about why Garner had come to inhabit such a state of unhealth. Why did Floyd, as well as so many Black people in this country, suffer from heart disease? Why did Garner, as well as so many other indigent folks in this country, suffer from obesity? Why did Garner, as well as so many other poor people of color, suffer from asthma? Why did Floyd and Garner, as well as so many other Black people, suffer from hypertension? The answers to this batch of questions do not involve malicious actors, but rather deadly systems and structures. And just a shout out to the novel coronavirus. At this point in the US's encounter with COVID-19, most are aware that the disease has disproportionately killed Black people. This is true because of racial disparities in health, because of structural racism, Black people suffer from higher rates of the underlying health conditions, the asthma, the hypertension, the heart and lung disease, the diabetes, that are risk factors for developing a particularly severe case of COVID-19. In other words, well before their encounters with the police officers who would eventually kill them, Eric Garner and George Floyd's bodies had already been damaged by the structural racism that has made COVID-19 particularly devastating among communities of color. Defining racism in the way that the liberal tradition proposes disallows us from looking at these broader issues. Instead, it keeps our attention squarely focused on the individual police officer who kneeled on Floyd's neck for close to 9 minutes. It keeps our attention squarely focused on the individual police officer who placed Garner in an illegal chokehold. In this way, we see that the liberal definition of racism suggests that in order to fix any race problem that the nation continues to have, no great societal reformation is necessary. Few will argue that there are a large number of bigots roaming the states in the post-civil rights era. Of course, bigots exist, and they might even occupy positions of power. Hell, they might even be police officers. However, most people across the political spectrum would probably all agree that bigots are in the minority in this country. Now, if racism is only individually held bias or prejudice, and if biased or prejudiced individuals are in the minority, then racism is an aberration. And if racism is an aberration, then racial justice will be achieved when these aberrant individuals are identified and denied the ability to harm others. The work of anti-racism then is simply to remove these blemishes from an otherwise perfectly good body politic. But if racism is defined more broadly, then there is nothing simple, pat, or easy about the work of anti-racism. Returning to George Floyd, the liberal definition of racism suggests that the work of anti-racism is to remove Chauvin from the police force if he is indeed a bigot. It also suggests that we need to implement procedures that will prevent other bigots from becoming police officers. And if we do those two things, problem solved. But if racism is defined in the way that CRT proposes, then more wide-ranging changes are necessary. And these changes involve addressing society's decision to criminalize nonviolent activities in which the poor, because of their indigence, disproportionately engage, like selling individual cigarettes from a pack. These changes involve creating legal opportunities for individuals to support themselves and their families financially. It also involves constructing a durable, generous, and non-punitive social safety net for those who find it difficult or impossible to be financially self-supporting. It involves reconsidering the court's interpretation of the Fourth Amendment. And these changes also involve addressing the citing of environmental hazards in poor communities of color, which contributes to the high rates of health problems among the residents of these communities. It involves making healthy food available and affordable in poor neighborhoods. And it involves tackling the myriad reasons why people of color in this country are sicker and die earlier than their white counterparts, which includes our two-tiered healthcare system and the deadly toll that racism-related stress takes on the bodies of people of color. And so this example reveals that CRT's definition of racism means that anti-racism requires an extensive, some would say radical, reordering of society. And so I will conclude by saying that I think we should protest George Floyd's death, but we should keep in mind that what we are protesting is bigger than Derek Chauvin. It's bigger than the Minneapolis Police Department. It's bigger than policing. It's bigger than the criminal legal system as a whole. We are protesting a racial order of things that has found a number of different ways to shorten and end non-white people's lives. Thank you.
Thank you, Khiara, for that terrific presentation. We're next going to hear from Professor Obasogie. He's the Haas Distinguished Chair and Professor of Bioethics, received an undergraduate degree from Yale, a law degree from Columbia, and a PhD from Berkeley. Osagie, I'll turn it over to you.
Great, thank you, Erwin, and many thanks to the Berkeley Law community for inviting me to be here. So I'd like to start by acknowledging that this is an extremely difficult conversation to have, and that many of us are still in the process of grieving and trying to understand what is happening. The talk that I'll give today will be fairly traditional, but please don't let this obscure the sense of frustration and disappointment that I have right now. To be sure, we have seen some truly beautiful moments over the past few days, with diverse groups of people from around the world coming together to say no more to racism, to end police brutality, and to affirmatively state that Black lives matter. But we can't escape the fact that we're here because Black people continue to be terrorized, maimed, and killed over absolutely nothing, and often by the state. George Floyd, Ahmaud Arbery, Breonna Taylor, and many, many others. We have to remember them and say their names. Much of my current work is at the intersection of constitutional law, policing, and medicine. So today, I want to briefly explore the role that medical examiners play in producing narratives of dysfunction about the Black body that compromise investigations into police killings. I'll start with a few comments about George Floyd's murder and autopsy, and then zoom out to offer a few broader thoughts on the relationship between medical examiners and prosecutors, and why reform is needed here as much as any other place in the criminal legal system. George Floyd was brutally killed by Minneapolis police officers 2 weeks ago today. And despite the gruesome video of Officer Derek Chauvin slowly killing Floyd over 9 minutes with his knee to Floyd's back and neck, it took 4 days for prosecutors to enter a criminal complaint. So there are two aspects of the complaint informed by the medical examiner that I want to focus on. First, the initial complaint describes the preliminary findings from Floyd's autopsy. It would be a few more days until the full report would be released. But at this moment, the medical examiner concluded that there were, quote, no physical findings that support a diagnosis of traumatic asphyxia or strangulation. So at one level, this is what one of my colleagues has called medical gaslighting. Here, the autopsy is being used to provide some type of medical or scientific evidence that our eyes didn't see what we thought they saw. Ultimately, the final autopsy from the medical examiner's office would rule that the manner of Floyd's death was a homicide. But we can see in these early moments the subtle ways in which medical findings are presented to the public to raise doubt about the responsibility of police officers, even when video evidence is clear and substantial. So what is also missing from this presentation of physical findings is context. Providing an initial autopsy report to the public saying that there was no physical evidence that Floyd was asphyxiated provides a sense that Floyd must have died from something other than the officer's weight on his body. But this presentation, without any other information, is at best deceptive. A collective of Black physicians wrote a statement in response noting that, quote, it is widely understood by medical professionals that asphyxiation can occur without physical findings, end quote. They also note that it was not only Chauvin's knee on Floyd's neck, but also the other officer's body weight on Floyd's torso that prevented his normal breathing mechanics. So in addition to all this, the initial criminal complaint against Chauvin revealed that Floyd had underlying health conditions that included coronary heart disease and hypertensive heart disease. The complaint then concludes by saying, quote, the combined effects of Mr. Floyd being restrained by police, his underlying health conditions, and any potential intoxicants in his system likely contributed to his death, end quote. Racial disparities in heart disease and hypertension are deeply entrenched and growing. Public health officials largely connect these disparities to various social determinants of health that produce worse results for Blacks, such as poverty, lack of access to fresh groceries, and higher levels of daily stress. But in the context of watching a man die from having a knee to his neck for 9 minutes, we have to ask, why does any of this matter? What we see in the Floyd autopsy is how the social, political, and economic group conditions of being Black are brought into the conversation to then explain why Floyd as an individual, and conversely, why the individuals might not be at fault. The story being painted by the medical examiner's report is one that has been told many, many times when police officers kill Black people. and that is a story of spontaneous death. A classic example of this was on display in the 1980s when the Los Angeles Police Department came under criticism for the number of Black people killed as a result of police officers using a chokehold. Then Police Chief Daryl Gates tried to explain this by saying, quote, "We may be finding that in some Blacks, when the chokehold is applied, the veins or arteries do not open up as fast as they do in normal people," end quote. So Daryl Gates is not a medical examiner. But what this quote highlights is the rather fluid nature in which law enforcement and their medical colleagues engage in banter that places the problem of Black death on the anatomy and pathology of Black people rather than on the abuse inflicted by police officers. It's a story that when Black folks are restrained by police, we somehow get all worked up, and our inferior anatomy and tendency to have various disease pathologies means that our bodies cannot take the strain that most other humans can, and that we somehow die through no fault of law enforcement. We also see hints of this in the initial criminal complaint, which oddly places, which oddly quotes one of the officers at the scene expressing concern while Floyd was being restrained. He's quoted as saying, quote, "I'm worried about excited delirium," or whatever, end quote. So this is an odd thing to say in the moment, and an even stranger thing to place in a criminal complaint. But it starts to make sense once we zoom out and place Floyd's killing in the broader context of the pandemic of police killings happening around the country. Excited delirium received its first modern use in the 1980s as a way to explain the acute onset of aggression, paranoia, or unusual physical strength exhibited by cocaine users that often led to their sudden death. Over the years, the condition has been detached from drug use per se to reflect a psychiatric condition that resembles a disturbed state of mind that can lead to adverse physical consequences and can lead to a person to die without explanation. In recent years, excited delirium has become increasingly used by law enforcement to justify using physical and chemical restraints and force against people, and also how that has been used by how that has also been used by medical examiners to explain why some people suddenly die in police custody. But here's the problem with all this. There is little evidence that excited delirium even exists. The diagnosis is not recognized by the American Psychiatric Association or the International Classification of Diseases, the two primary authorities on identifying psychiatric conditions. Excited delirium emerged in the context of other racist and unfounded medical diagnoses created in the midst of the 1980s crack cocaine epidemic to explain the behavior and outcomes of drug users. And while these other racist diagnoses have been exposed for their problematic framings of Black people, excited delirium has persisted and mutated to become a favorite explanation by medical examiners and law enforcement to explain why Black people suddenly die in police custody. Put bluntly, it's a made-up medical condition that's being used to hide police brutality. I'm currently in the process of documenting how excited delirium has become a central explanation and defense in situations where police kill. But the initial findings are quite disturbing and highlight the extent to which medical examiners and other healthcare professionals participate in covering up and explaining away police killing people. So I'll conclude by quoting the last line of the press release that describes George Floyd's autopsy results. It says, quote, under Minnesota state law, the medical examiner is a neutral and independent office and is separate and distinct from any prosecutorial authority or law enforcement agency. Ask any lawyer and they will tell you about the questionable relationship between prosecutors and law enforcement. While they are supposed to work independently, it is well known that they often work together against the interests of victims of police violence. It is time that we also turn a critical eye towards medical examiners and demand that they be held to high standards. Right now, in the context of police killings, medical examiners are behaving like cops. They are part of the same blue wall of silence that uses medicine to cover up the police officers' unimaginable brutality. And our communities deserve better. Thank you.
Thank you, Osagie, for those wonderful remarks. Next, we're going to hear from my colleague, Professor Roxanna Altholz. She's a clinical professor of law here at Berkeley Law. She's co-director of the International Human Rights Clinic. She's an undergraduate degree from Brown, a law degree from Berkeley. She's recently completed a major study with regard to the Oakland Police Department. Roxanna, thank you.
So I want to also thank Erwin for inviting me to join the panel. I feel privileged to participate in this discussion about accountability for state violence and the need for transformative justice with the other panelists and also with this community. I want to start by adding my voice to the so many others denouncing the brutal state-sanctioned killing of George Floyd, Breonna Taylor, and many, many others, and recognize that if it weren't for the dedication of anti-racist organizers who gave of themselves for years and years to give us this possibility of creating an astonishing future, we would not be here today. I want to also recognize that we've seen Black-led multicultural protests taking place in 114 cities in 21 countries over the last 14 days. And the work is just beginning, but personally, that gives me a tremendous amount of hope. Today, I'm going to talk about crime victims' rights and policing. I hope you can see my slides. I'm going to examine how, even with regard to the most serious of crimes, homicide, police, prosecutors, government, social workers disregard the trauma of Black and Latino crime victims, often exacerbate the impacts of violence, and fail to provide adequate support and assistance. During today's presentation, I will identify some of the specific laws and law enforcement behaviors that foster what Monica Bell has called legal estrangement. And this is the perspective held by many from poor communities of color, that the police are illegitimate, unresponsive, and ill-equipped to ensure public safety. My remarks are based on the findings and conclusions of a study the clinic issued earlier this year about unsolved murders in Oakland. I'm going to use quotes from the interviews we conducted for that study to center perspective and insights of family members of Black and Latino homicide victims whose murders remain unsolved. I want to begin by providing some context about Oakland communities that experience high rates of victimization. Oakland has a long history of political activism and civic engagement. Just in the last few days, local high school students of color have organized protests and marches attended by tens of thousands. Oakland is also one of the most racially diverse cities in the country, with significant numbers of white, Black, Latino, and Asian residents, although gentrification is eroding that diversity. Oakland also has a long history of racial discrimination and racism, perpetrated both by private and public action that has deprived residents of color of housing options, employment opportunities, political power, and access to healthcare, and subjected residents of color to over-policing, police brutality, under-resourced schools, and unhealthy environments. Since the 1990s, Oakland has had some of the highest rates of violence in the country. Per capita, Oakland's homicide rate has been consistently 3 to 6 times state and national levels. In the last decade, approximately 76% of the city's homicide victims were Black. During that time period, police made arrests in approximately 40% of Oakland homicides involving Black victims and approximately 80% of homicides involving white victims. In East and West Oakland neighborhoods where most of the city's Black families live, police made an arrest in less than a third of murders. As a result of high rates of violence and low arrest rates, the Oakland Police Department has over 2,000 cold homicide cases on its books. These graphs and numbers give us a partial image of twin maladies, violence, and what in the human rights field we call impunity.
Oakland is not war-torn Bosnia or Colombia, but the ways the state has failed families of Black homicide victims implicate human rights. The systematic failure to prevent violence, investigate, and provide support and assistance to family members without discrimination in Oakland is arguably a violation of international human rights law. By using the concept of impunity, I want to draw attention to the underexamined impacts of unsolved murders on family members of the victim and surface the consequences of over-policing and under-policing Black and Latino communities, and the consequences of denying Black and Latino crime victims equal access to government assistance and support. Nationwide, the experience of impunity for homicide is most familiar to Black families. An investigation by the Washington Post found that police failed to make arrests in 26,000 homicides during the last decade. And more than 18,600, or 71.5% of those unsolved homicides, the victim was Black. African Americans, especially Black youth, are at a disproportionate risk for exposure to violence and trauma. Nationwide, homicide is the leading cause of death for African American men ages 10 to 34, and Black youth are 7.8 times more likely than whites to experience the homicide of a loved one. On average, African Americans experience the homicide of 2 loved ones in their lifetime. As disturbing as these numbers are, they tell us little about the lived experience of family members in the unsolved murder cases. A more detailed picture emerged from the interviews we conducted with family members of Oakland homicide victims. Every homicide leaves a disaster in its wake. The family members of homicide victims experience diverse, intense, and prolonged impacts that affect every dimension of their lives: psychological, emotional, behavioral, physical, financial, occupational, social, and spiritual. A study found that 50% of family members show symptoms of PTSD, and almost a quarter had developed the disorder. 27% of family members interviewed for one study had quit their jobs within 2 years of the murder or were fired after missing work. One father I spoke with said that the daily pain associated with the loss of his son was like having to crawl through broken glass. Oakland law enforcement practices can and often do exacerbate the adverse impacts family members experience. Our research indicates that law enforcement treatment of family members at critical moments, during death notification, at the crime scene, during the subsequent investigation, often generated mistrust, frustration, and exacerbated stigma felt by the family members we interviewed. The Oakland Police Department does not have a protocol for death notification. The vast majority of family members we interviewed learned of the homicide first from family, friends, or strangers rather than an officer of the law. This quote is from a father describing the desperation he felt for official information about his son. He told us, "I went to the morgue. I was banging on the morgue door. I was telling them to open the door. I was trying to get them to open the door so I could run in because I needed to see my son's face. I would have gotten arrested to see him. I didn't want to hear second, third hand. I wanted to know from the officer that was on the scene." The Oakland Police Department does not have a protocol for addressing the needs of family members at the crime scene. At the crime scene, family members encountered police who were ill-equipped to address their grief and trauma. Family members described the experience with OPD at the crime scene as hurtful and very traumatic. Some family members, like what is described in this quote, were threatened with arrest or arrested when they tried to find out what happened. This brother of a 2011 Oakland homicide victim told us, "The police didn't give me any information. They told me to go, 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 not telling me where to go, but just telling me to go. I explained to them that that was my brother, then they kept us off to the side without giving us any information. My brother's laying there dead, then my other brothers came. The police tried to arrest my youngest brother because he was trying to figure out what was going on." The Oakland Police Department does not have a protocol for communicating with family members during the investigation. The vast majority of family members we interviewed spoke with detectives in the days after the murder and then had no contact with investigators for extended periods of time. This quote describes a typical experience. Most family members rarely, if ever, received updates about the investigation or even a return phone call from investigators. This is another quote that describes the mother's response to the police's lack of communication. This mother of 2000 of double homicide victims from 2000 said, "I could not understand why the police investigators were so seemingly negligent and their way of communication was so harsh, because we're already very fragile. Like a rose, when you pinch it, it's going to bruise. I didn't know what to do, so I just became angry one day and I went to the police station and I said, somebody's going to talk to me. I'm not leaving here until I talk to the chief, excuse me." The OPD's approach to communication really varied widely. Some investigators provided family members with information about the identity of suspects, even though they had no intention of arresting, and did so with seeming disregard for the risk it would spur retaliatory violence. These gaps and shortcomings exist, although more than 40% of Oakland's general budget, a higher percentage than in many other cities, goes to the police department. OPD chronically understaffs its homicide section. In 2013, for example, each of Oakland's homicide investigators handled a caseload of more than 20 homicides. According to experts, a caseload should not exceed 4 to 6 homicides per investigator per year. The stakes really could not be higher for law enforcement during these investigations. When law enforcement disregard, or discriminate against family members who have suffered the devastation of homicide, they're sending a message about the victim's value to society and challenging their family's sense of belonging. As described in this quote, they're breaking a social contract. The majority of family members we interviewed for this report had experienced the homicide or shooting of more than one family member. One man we interviewed, his son's mother, brother, and his nephew had been killed in separate incidents in Oakland, and all the murders were unsolved. Most families we interviewed did not believe the police had conducted a reasonable investigation and that their loved one's murder, into their loved one's murder. Most believed law enforcement's prejudice and bias contributed to the police's failure to solve the murder. Many family members said the police treated them like criminals and the victim like a number. The term public service murders was used to describe the family members' perception of how the police viewed the death of young Black men in Oakland and why the police did not properly investigate them. And this is a quote from a mother of a homicide victim and who is a crime victim rights advocate. She told us that the average family member that I work with does not feel supported by the system. They don't feel valued. They don't feel that their child's life was valued. It doesn't matter if a child was on drugs or even if the child contributed to the crime. For a mother, that's our baby. That child was born bones of our bones, flesh of our flesh. Family members also describe their repeated efforts to counteract the pernicious effects of bias and racism. They repeatedly called investigators. They went to the police station. They conducted parallel investigations, often at their own peril. Some of Oakland's most important community-based organizations that are currently providing services to families of homicide victims were created by the mothers of homicide victims. What emerged from the interviews was that the lack of justice, stigma, and blame collided to disenfranchise the grief of family members. Law enforcement behaviors and laws have cast young Black victims of homicide as culpable for their own deaths and denied their loved ones the right to grieve. In recent years, the federal government has allocated $2 to $3 billion each year for crime victims' rights services and compensation programs. Every state in the country has a program to compensate and assist crime victims. Each year, the state of California allocates tens of millions of dollars to help crime victims and their families with expenses resulting from the crime. California law, like many other states, establishes a distinction between deserving and undeserving victims and has invested police with the authority to decide who qualifies as a crime victim, who has legal rights as crime victims. This slide summarizes the grounds for eligibility. California crime victims and their families who are on probation or who the police determine were involved in the death or who do not cooperate with the investigation are ineligible for financial assistance with the funeral, medical, and mental health expenses and relocation. One study has found that the laws that bar crime victims with criminal records from receiving state financial assistance disproportionately impact Black crime victims. Oakland community-based service providers told us that the police often leverage their authority to deny access to government assistance to compel family members to cooperate with the investigation. However, several family members reported that the police do not respond to their requests for protection. The support that eligible family members of Oakland homicide victims receives is modest, usually less than $500,000 a year in total for everyone. Financial assistance covers limited expenses and services for a maximum of 2 years. Family members who continue to experience the consequences and effects of impunity for more than 2 years, from the government's perspective, are on their own. When we asked about their expectation for justice, most family members expressed an expectation and desire for the traditional justice system to hold the person responsible for the murder accountable. But behind this call for accountability was a desire to prevent future violence, as what is represented in this quote. It's very hard for me because I feel like this little boy is going to hurt somebody else. I don't want to see another mother go through what I'm going through, not even his mother. Most family members held a more holistic view of justice than is accommodated by a police and court-centric approach. Another mother whose son had been killed, a caregiver really, whose son had been killed and who herself worked in the prison system, expressed her thoughts about incarceration in this way. In my utopia world, offenders would have to go through one of the many programs that I know is effective in helping people who cause harm gain empathy and accountability for the harm and heal from their own harm. Because I have not met anybody, and this is my 33rd year working in the prison system, I have not met anybody who's caused harm who had no harm done to him. That opportunity to heal should supersede punishment. From the perspective of many family members, justice should address their needs by providing support and assistance and by honoring the memory of the victims. A family member put it succinctly when she said that when the victims' families are left behind hurting and abandoned, justice is not served. I know I'm out of time. I look forward to the Q&A and the opportunity perhaps to speak about recommendations.
Thank you, Roxanna, for that wonderful presentation. I'm the last speaker on this panel, and I should say a word about why it is I'm speaking and my perspective. In part, my perspective comes from being a lawyer. For over 35 years, I've handled appeals on behalf of victims of police violence. I have a certiorari petition right now pending in the Supreme Court on behalf of the family of a man who died as a result of police abuse, ironically in the Minneapolis area. At the same time, I speak to this perspective of a scholar who's been teaching and writing about this for a long time. By coincidence, I'm right now working on a book about the Supreme Court and the police. My views, most of all, though, with regard to policing, were shaped by an experience almost 20 years ago in Los Angeles. I was asked to do a study of the Los Angeles Police Department in light of the Rampart scandal. I worked with a group of civil rights lawyers in doing this. I interviewed almost 100 police officers, many prosecutors, public defenders, judges. What I learned at the time was that Los Angeles was in a cycle that kept repeating itself. There would be a tragic incident involving race and policing. There would be a commission to study the Los Angeles Police Department. It would make recommendations. Some would be adopted, some not. The city would declare victory over the problem until the next incident, and the cycle would repeat itself. I believe that same thing has gone on in the United States. And my hope is that what we're seeing now in protests across the country will break that cycle and lead to meaningful reform. What I learned in doing the study of the Los Angeles Police Department is that cities rarely will voluntarily reform their own police departments. That police departments virtually never will reform themselves. That successful reform of police almost always is going to require external mandates and external oversights. Well, how can that be achieved through the law? The most obvious way is through lawsuits against cities, against police departments, against individual officers. But unfortunately, the Supreme Court has made it very difficult and almost impossible in some instances to sue, whether it's the city, the police department, individual officers, which then means that the Supreme Court has contributed enormously to the problem of policing and the problem of race and policing in the United States. Often, there's a desire to sue cities and police departments for injunctions to reform policing practices. But the Supreme Court has made that difficult, if not impossible. The key Supreme Court case here was City of Los Angeles versus Lyons in 1982. Adolph Lyons was a 24-year-old African-American man who was stopped by Los Angeles police officers for having a burnt-out taillight. The officer ordered Lyons out of his car. The officer slammed Lyons' hands atop the roof of the car. Lyons complained that the keys in his hand were cutting into the skin of his palm. The officer then administered a chokehold on Lyons and rendered Lyons unconscious. Lyons awoke. He was spitting blood and dirt. He had urinated and defecated. He was given a traffic citation and allowed to go. He did some research and discovered to this point 16 people in Los Angeles had died from police use of the chokehold, most all like him, African-American men. And of course, it was a police chokehold much more recently that killed Eric Garner just a couple of weeks ago, killed George Floyd. Adolph Lyons sued the Los Angeles Police Department for an injunction to keep officers from being able to use the chokehold except where necessary to protect the officer's life or safety. But the Supreme Court ruled that Lyons lacked standing to sue. The Supreme Court said Lyons could not show that it was likely that he personally be choked again in the future. The Supreme Court said that a plaintiff like Lyons who's seeking an injunction has to show a likelihood of future personal injury. This makes it so difficult for victims of police abuse to be able to sue in court for systemic reform of police departments. There's one case in Chicago where women who were stopped for routine traffic violations were subjected to humiliating, degrading strip searches by the police. They wanted to sue the Chicago police to stop strip searches when people were just being detained for traffic violations. But the court said these women lacked standing to sue because they could not show it'd be likely they would be stopped again and that they would be subjected to the strip searches. I have had so many conversations the last decades with civil rights lawyers who wanted to bring suits for injunctive relief against police departments. They have a plaintiff who suffered a terrible, sometimes even a fatal injury, but they can't sue because they can't show it's likely to happen to that person again. Well, if the suits aren't for injunctive relief, then they need to be for money damages. But here too, the Supreme Court has closed the courthouse door, made it very difficult to bring suits for money damages, made it very difficult to use the law to reform policing. One possible defendant is the local government, the city, the police department. But the Supreme Court has made it very difficult to sue cities, sue police departments. The key Supreme Court case here is Monell versus Department of Social Services in 1978. There, the Supreme Court held that a local government could be sued only if its own policies violate the Constitution. A city can't be sued on a respondeat superior basis. All law students learn in first-year torts that if an employer has an employee who commits a tort on the job and the scope of duties, the employer then is liable for money damages. But not so when it comes to constitutional violations. A city is liable only if you've proven that its own policy violates the Constitution. The Supreme Court has made it very difficult to show a municipal policy, and often in the context of police abuse cases, this means no recovery at all. Let me just give a couple of examples. The first is a Supreme Court case not quite a decade ago, Connick versus Thompson. John Thompson spent 18 years in prison on death row for murders that he didn't commit. At the time of his trial, the deputy district attorney had blood evidence that was linked to the assailant, John Thompson. The deputy attorney was required under the Constitution, under Brady versus Maryland, to allow the defense to test the blood. The deputy district attorney hid the blood evidence. In fact, many years later, when the deputy district attorney was literally on his deathbed, he told another deputy district attorney about it, and that deputy district attorney told no one. Thompson was convicted, sentenced to death. Just weeks before scheduled execution, through a series of coincidences, his defense lawyers learned of this blood evidence. Thankfully, it was still in the police evidence room. They were able to have it tested. Not only didn't it match Thompson's DNA, didn't even match his blood type. There was a new trial. He was acquitted. He sued the city, saying that the prosecutors were responsible and that the city ultimately was responsible because of a long pattern of Brady violations. But the Supreme Court ruled against John Thompson. They said, this is just one incident. You can't prove a city's liable through one incident. Justice Ginsburg, in the sense that it wasn't one incident. 5 different deputy district attorneys knew of the blood evidence and didn't speak up. There's a long pattern of Brady violations in Orleans Parish. Also, this wasn't even the only Brady violation in this case. There was a witness who described the assailant as having short hair. John Thompson at the time had a large afro. Nonetheless, the Supreme Court said no recovery because of no city policy. Or an example directly about police abuse. Supreme Court case, Board of Commissioners of Bryan County versus Brown. A sheriff hired a nephew. The nephew should have never been on the police force. He had a long history of violence and of criminal violations. In fact, the sheriff even knew this. He wouldn't give him a gun because of the concern. This deputy sheriff stopped somebody, pulled the people out of the car so harshly that the woman needed knee replacements in both knees. Sued the city here, saying its policy of deliberate indifference with regard to training and supervision was responsible. The Supreme Court ruled the city couldn't be liable because the city couldn't foresee this specific injury. In case after case, the lower courts have refused to allow damages against cities for violations of rights by police. Here's why it matters. If cities are held liable for money damages, that will give them an incentive to reform the police. If the cities don't face that liability, the incentive isn't there. Also, the victims don't get compensated. Then there's the possibility, the alternative, of suing the individual police officers. Any government officer who is sued for money damages always has an immunity defense. Some have absolute immunity. Prosecutors have absolute immunity for their prosecutorial acts, even if it involves knowingly using perjured testimony. Police officers have absolute immunity to civil suits for money damages if they commit perjury in court. But if there's not absolute immunity, this was called qualified immunity. And any police officer who sued for money damages for a constitutional violation has qualified immunity. The Supreme Court has said that qualified immunity means that a police officer is held liable only if he or she has violated clearly established law that every reasonable officer should know. The Supreme Court has said it has to be a right established beyond dispute, and it has to be at a specific level of abstraction. In case after case, the Supreme Court is denied recovery against police when there's been excessive force based on qualified immunity. I'll mention just a few quick examples. There was Plumoff versus Rickard about 6 years ago. Police officers stopped a car from having a burnt out headlight. The officer asked the driver whether he'd been drinking. The officer asked the driver to get out of the car. Rather than do so, the driver sped away. There was about a 100-mile-an-hour short chase. At one point, the officer thought he had pinned the driver of the car, but the driver got away. The officer then began firing at the car, fired 3 shots. The car kept going. The officer fired 12 more shots. The driver and the passenger were both killed. Now, the officer could have let them go. They had the license plate number and tracked them down later for driving with a burnt out headlight, for evading arrest. Or the officer could have tried other things other than 15 shots. A lawsuit was brought, and the United States Court of Appeals for the Sixth Circuit said it could go forward to the jury. But the Supreme Court said no. The Supreme Court said when an officer fears possible harm to pedestrians, the officer can shoot and keep shooting until the car stops. The court said the officer protected by qualified immunity. Or another case, White versus Pauley, from just 2 years ago. The police followed a car off of the freeway. When the police got to the house, the people who were in the car being followed got out and went behind a wall. The officers and the people were talking. Another officer came onto the scene and immediately began firing shots. The officer just came on the scene, killed one of those people. A lawsuit was brought against the officer for doing this. The Supreme Court said, reversing the lower court, that the officer was protected by qualified immunity. Or another case from a couple of years ago, Casella versus Hughes. Police officer was called to a scene. There was a woman who was obviously at the time mentally disturbed, hacking away at a tree with a knife. The officer told the woman to put down the knife. When she didn't do so, the officer shot and severely wounded the woman. The woman sued. The officer wasn't in danger. The knife was nowhere near him. The Ninth Circuit said it should go to a jury. But the United States Supreme Court said that the officer is protected by qualified immunity. As many, including conservative scholars and conservative activists, have said, the Supreme Court has moved qualified immunity to being virtually absolute immunity, which means we can't successfully sue police officers for excessive force. The deterrent that's lost from such suits is lost. Victims don't get compensated. A bill was introduced into Congress just today to eliminate or at least greatly modify qualified immunity to allow the legal system to provide recourse. Now, I have focused on what we as lawyers would want to do, filing lawsuits against government, against police officers for reform. And I've tried to talk about how the Supreme Court has made it difficult. There is another tool that exists, a very important one with regard to police reform. It's a federal statute, 42 United States Code, section 14141. It specifically says that the United States Department of Justice can sue police departments when there's a pattern and practice of police abuse and violations. This lets the Justice Department bring the suit, and often it leads to consent decrees that reform police departments. There were such consent decrees entered in many cities, Baltimore, Cincinnati, Seattle, that brought about reforms. In the early 2000s, after the Rampart scandal, the Justice Department told the city of Los Angeles that it was going to be sued. And the city and the Justice Department entered a consent decree that's over 100 pages long. It did things that should have been done a long time ago. It created a system for tracking disciplinary violations of officers. It required that officers track the race of the individuals who they're stopping, something crucial in eliminating and at least providing a remedy for racial profiling. It created an external monitor of the Los Angeles Police Department. There's certainly much more that need to be done, but these consent decrees made a difference. Unfortunately, Attorney General Jeff Sessions said that the Justice Department was not going to use the authority under 14141, believed it was intrusion into local police departments. In fact, they even said they weren't going to enforce existing consent decrees. Attorney General William Barr has followed that. So just as the courts have been closed off, so has the Trump administration closed off using this very important tool that exists in federal law. Now, some of what I've talked about would require the Supreme Court changing doctrine. Overcoming Lyons would require the Supreme Court change the standing doctrine of the Constitution. Some can be done by Congress. Congress can modify the civil rights law to make cities liable on a respondeat superior basis, the city liable for constitutional violations of officers. Congress can change qualified immunity. It's not constitutional. A different administration can choose to use 14141. But I'm totally convinced that in order to ultimately achieve meaningful police reform, there needs to be external mandates and external oversights. We need to overcome the legal obstacles that I've just been talking about. So you've now had the chance to hear from 4 panelists, 4 different perspectives. We have about 5 minutes left. Whitney, if you want to ask some questions. I know there's only a few minutes left for questions.
Yes, happy to. I've received a number of questions. So first, could the panelists share their thoughts on A, defunding municipal police departments, and B, large universities like ours cutting ties with police departments, as has been done in Minnesota public schools and universities?
Maybe start with each of the panelists in order. Khiara, Osagie, Roxanna.
Yes, so I'll start. I think that we should keep in mind that Eric Garner's death, Philando Castile's death, Stephon Clark's death, George Floyd's death, all of these, Breonna Taylor's death, all of these deaths have taken place within a context of mass incarceration. Our country imprisons more people than any other country in the world. We have higher rates of incarceration than any other country in the world. What that means is that when we have a problem in this country, we turn to the criminal legal system. We build more jails and prisons. People are using drugs, build more jails and prisons. People are stealing food, build more jails and prisons. People are assaulting others, build more jails and prisons. We have limited our imagination because we have relied on the police and the criminal legal system for so long to address our social problems. And during my talk, my remarks, I talked about several, and please note that list that I gave was not exhaustive. I talked about providing foods and vegetables that are affordable and accessible in poor communities. I talked about erecting a durable, non-punitive social safety net. I talked about addressing our 2-tiered healthcare system and the fact that when you are poor, the care that you get is something that ought not to be found in one of the wealthiest countries in the world. When in order to address those issues that I identified, it takes money. And when you ask budgets, people who construct budgets, when you ask folks who guard money, they tell you that there's no money for it, right? They tell you that it's zero sum. We spend a lot of money on policing. We spend a lot of money on building jails and prisons. What I understand the efforts to defund to be about is about diverting that money that we spend on using the criminal legal system to address social problems and using that money on a social safety net, on foods, fruits and vegetables, on healthcare. It makes all the sense in the world. Again, we have limited our imagination because we've always led with the criminal legal system in this country. These protests are an opportunity to reimagine what we want our society to be like. And so I fully support efforts to defund.
We have a couple of minutes left. Maybe Osagie and Roxanna, if you each take 1 minute.
Sure, just to follow up on Khiara's comments, I agree with everything she said. I guess the only thing I would add to that is that I think it's important as we think about these defunding efforts to keep in mind that the vast majority of tasks that police officers do not require a service weapon. And so we have to radically reimagine how can we kind of use community resources to address problems that happen in society that a specialist, someone who's trained. So for example, mental health crises. Too often, folks have mental health crises and we send a police officer with a gun in there and tragic things happen. So as we think about defunding and reallocating resources, we have to think about what is the architecture that we need to create community responses so that we can deal with these problems in a way that, specialists who are trained in de-escalation and negotiation, rather than people who are untrained with weapons, are put into those situations so that we can both solve social problems and make sure that everyone walks out of those situations alive. So as we have the defunding conversation, we have to also imagine what that structure looks like and making sure that structure prioritizes the health and safety of all community members.
Yeah, I absolutely agree with what Khiara and Osagie have said. I would just add, I hope from my presentation, what I was able to communicate was how the police, Oakland police particularly, is failing at their core functions. Oakland police has been under a consent decree for a decade and a half. We've seen scandals for 3 decades in the Oakland police, the most recent involving the exploitation of a minor by so many of the in power in the Oakland police, in the high in the hierarchy and rank and file, that we, I think, had 4 changes to the chief of police in a period of 2 weeks. So it is when you have the police failing at the core function of solving homicides, it's important to really examine whether it makes sense to continue with this configuration, to continue and allowing the Oakland police to function. I'd also add to some of what Khiara and Osagie said, just to flag the situations in which police serve as gatekeepers to accessing services, support, and assistance. And that's certainly the case when it comes to crime victims. Police can, as I explained, deny access to those services for reasons that are not well established. And I think that opens up for the opportunity for racism and prejudice and bias to operate quite vigorously.
I apologize that we're out of time. I know there are many questions we can get to, but this is just the first of many programs and forums that we'll hold on issues of race and race in policing. I began this afternoon by quoting the Kerner Commission from 1968. And its preface begins by saying that what it's doing is just a start. It said, it can only be a beginning because patently until the fact of white racism is admitted, it cannot be conceivably expunged. To begin by saying, but a journey of 1,000 miles, President Kennedy used to say, must begin with a single step. I know that this program is just a single step, but I hope it's one of many that we will take together, try to pursue justice in this area. I hope too that you'll join me very much in thanking Khiara, Osagie, and Roxanna for their wonderful presentations today. And thanks all of you for being part of this.